Sometimes I can give people choices. Sometimes I can not give them choices. I always tell people, you can't choose how your recovery is going to look like in the sense of, I want this treatment, I don't want that treatment. Because if you could do that and write your own program, we wouldn't be here and you wouldn't have the criminal history that you have. Court is calling 2024 CR 5390, State of Texas versus George Leverne Hawkins. Could our parties announce for the state?
Andrew Harris, with the state.
Defense?
Renee Munoz.
And are you Mr. Hawkins?
Yes, ma'am.
You entered a plea on June 20th, 2024 to the offense of assault of a peace officer. According to the plea bargaining agreement, punishment must be assessed at 6 years in the prison. The state is silent on your application. They're taking in consideration 2023 CR 7315, 2024 CR 5389, County Court Cause number 729000. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Judge.
Any objections to the PSI report? State?
No, Your Honor.
Defense?
No.
Have both parties had a chance to review the TAP evaluation? State?
Yes, Your Honor.
Any objections?
No, Your Honor.
Defense?
Yes, Judge, and no objections.
All right, the state is silent. Defense, do you have any witnesses?
No witnesses at this time, Judge. Only a clarification, explanation / argument.
All right, you may proceed.
Thank you, Your Honor. With regard to Mr. Hawkins, I've been dealing with him for some time, assisting with these legal matters. He has been keen and set on taking advantage of the specialty court because I believe that specialty courts are designed for individuals like Mr. Hawkins that are dealing with issues and they need that support and structure from a team that can help them understand their issues and put different resources in the community. We did apply for Veteran Treatment Court on May 30th. He was denied that court, albeit being a veteran and having served this country honorably, receiving honorable discharge, because there is not a sufficient nexus between his issues and the service, according to the program, Judge. So after that denial of that program, we went ahead and had him considered for lifetime recovery. We did reach out and have him screened, and we do have documentation here that he does meet criteria and can go there if allowed by the court. We also reached out to felony drug court in advance to see if he would meet criteria for that program as well. I do have documentation here that he does meet criteria. However, he was denied at that time because it is obviously, the court is well aware, post-adjudication program, and we're not at that stage as of this time. So, Judge, he's been dealing with some issues. He did graduate from University of Houston with an accounting degree in 2010. However, some of the issues he's dealing with, namely surrounding substance use, he uses methamphetamine, things of that nature, had led him to be homeless and have some interaction with law enforcement. The nature surrounding these offenses are not of an egregious type. He was arrested and fled out and made contact with the officer's shin, I believe. The other offense that he was charged with, Judge, he was actually at Cross Point, and he was going to be emergency detained from there and taken to a facility. However, he was routed to the jail upon them alleging to have spit on the back of the officer's head. So there is some issues here. We don't believe that the issues are necessarily attributable to a criminal mindset, more so a cry for help and need for treatment, Judge. So we're asking the court to consider the avenue of treatments with inpatient treatment facility. I referenced the PSI, and the PSI is recommending inpatient treatment. We're asking for that to be ordered, Judge, so he could be transferred from here to lifetime recovery, have him doing well.
But what is this says in the report? He declined to have a mental health screening, stating he didn't want to sign for any of the department's dual diagnosis programs or residential programs because he doesn't like the idea of sitting in jail for 4 months just to go to treatment.
Yes, Judge. And if I might clarify that, I believe he's maybe had heard word around the jail that maybe the DDRF times are long. They could result in months-long waits to get him into facility. And I think that he's been in custody for a number of months now. He's wanting to get a hold on his treatment and recovery, and believes that lifetime recovery would probably be less of a wait time to get him into that treatment, Judge. So I did explain that in the PSI with him, and he stated that was his concern about the mental health facility being much longer wait, and him waiting in custody until a bed opens up, where in contrast to that, the Bexar County is notifying me that they do have space for him at lifetime recovery, and they can readily transfer him there to get him on the road to his recovery and to turn his life around. And my suggestion, I think the court hopefully is on the same mindset, that if he does that, it's going to put him in a better place to work the felony drug court program, which he meets criteria for, and give him that access to that specialty court, which we were vying for and trying to get with the Veterans Treatment Court, but he did not meet criteria for that, Judge. For these reasons, we're asking respectfully for the court to consider that. I do have the treatment documentations of been evaluating him, Judge, as well, for the court to consider, just to verify. It's my understanding, confirmed with the state of Texas representatives, that they're silent as to this request because they see the need for him to get some treatment and some help. And he's been patiently waiting for us to try to get it together to hopefully create these avenues for him. And I think we have some options and availability here, Judge, to get him some treatment over just incarceration.
All right. I see that he is a veteran and was honorably discharged.
Yes, Judge.
And it appears from reviewing the history and reviewing the instant case that there is an issue with drug use. There's an issue with mental health. Now, whether that mental health occurred due to his military service or not, the court doesn't have that information. So I'm going to give you a choice. Sometimes I can give people choices. Sometimes I can not give them choices. I always tell people, you can't choose how your recovery is going to look like in the sense of, I want this treatment, I don't want that treatment. Because if you could do that and write your own program, we wouldn't be here and you wouldn't have the criminal history that you have. I'm going to give you a choice. Sometimes I can give people choices. Sometimes I can not give them choices. I always tell people, you can't choose how your recovery is going to look like in the sense of, I want this treatment, I don't want that treatment. Because if you could do that and write your own program, we wouldn't be here and you wouldn't have the criminal history that you have. So I can sentence you to 4 years in prison, or what's going to end up happening is I'm going to refer you back to felony drug court because I know they have a dual diagnosis program. If they don't accept you, you're going to safety. So those are your choices.
Is, Your Honor, for clarification, the felony drug court dual diagnosis, is that within the felony drug court
Yes.
program? Would it still be an avenue for him to get treatment at lifetime recovery? If
He's going to felony, if felony drug courts accepts him, then drug court will set his conditions. If felony drug court does not accept him, he's going to safety.
Okay, yes, understood, Judge. If we could be considered for the felony drug court, and then whatever recommendations they may have, as long as they're reasonable, Judge, we'll definitely, he'll be on board with that.
No, I mean, felony drug court, it doesn't matter if people think their recommendations are reasonable or not. It's, if he goes to felony drug court, then felony drug court is going to set his conditions. If he goes to felony drug court and he says, I don't want this, then what's going to end up happening, a motion to revoke is going to be filed.
Yes, Judge, I understand. And ultimately, we're looking for an avenue for him to get treatment through a specialty court. So that's with the recommendation of felony drug court piece. He wanted me to voice that he would like to be considered for that and take part of that program. All
right. The court is going to sentence you to 8 years deferred adjudication. Take in consideration 2023 CR 7315, 2024 CR 5389, 729,000. He's to remain in custody for the following evaluations. A referral to felony drug court. If not accepted, then SafeP, followed by aftercare. And then MIC evaluation, regular reporting by Zoom or in person, regular random UAs, proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Anger management. Field visits, one time per month until further notice. And I'm sorry, instead of the anger management probation, it's going to be this a hostility management aggression control program. There's to be no contact with K Talley, Talley. And probation with regards to the MIC, maybe the best place for that if he's not accepted in to felony drug court. Once he's relieved from SafeP, if we do the mental health treatment through the VA. Probation, also, we'll do 200 hours of community service restitution. Probation, is there anything else he needs? I'm sorry?
No, sir.
Is there anything else you need from the court to be successful?
No, Your Honor. Thank you.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Understood.
Do you understand?
Yes, ma'am.
And the court did not see any restitution amount for the officer. So state if there is going to be restitution to the officer, you will need to provide that within 30 days.
Yes, Your Honor.
All right. Is there anything else?
Nothing further, Judge. Thank you for allowing us to be heard on this matter.
All right. Thank you.
George Leverne
Court is
Hawkins
calling
appeared
2024
before the court after
CR
pleading guilty to
5390,
assaulting
State
a
of
peace
Texas
officer.
versus George
During
Leverne
sentencing,
Hawkins.
his attorney
Could I have parties
emphasized
announced
that
for the
Hawkins is
state?
an honorably discharged military veteran who earned an
Andrew
accounting
Harris,
degree,
Secretary of
but
State.
later
Defense?
struggled with
Renee
substance
Munoz.
use,
And are you
mental
Mr.
health issues,
Hawkins?
and
Yes, ma'am.
homelessness.
You entered a
The
plea
defense asked the court
on
to
June 20th,
prioritize treatment over
2024
incarceration, explaining that Hawkins had
to the
already been
offense of
evaluated
assault
for
of
several
peace
recovery
officer.
programs and was willing to
According to the
participate
plea
in
bargain
structured
agreement,
rehabilitation
punishments be assessed at
Judge
6 years in the
Boyd
prison. The
acknowledged his
state is
background,
silent on your
but stressed that
application.
recovery cannot
They're
be
taking in
tailored to
consideration
personal preferences and
2023
requires
CR
full commitment to
7315,
court-ordered conditions.
2024
Instead
CR
of sending him directly to
5389,
prison, the
County
judge
Court
placed
cause number
Hawkins on 8 years of deferred adjudication community supervision
Have both
with
parties had a
strict
chance to review the
requirements.
PSI
He was
reports?
ordered to
State,
undergo evaluations,
Yes, Your Honor.
treatment through
Defense?
felony
Yes,
drug
Judge.
court
Any
if
objections
accepted,
to the PSI
comply with
report? State,
supervision,
No, Your
complete
Honor.
community
Defense?
service,
No.
and follow
have both
all
parties had a
program
chance to
rules.
review the TAP
The court warned that
evaluation?
failure
State,
to comply could
Yes, Your Honor.
result
Any
in more
objections?
serious
No, Your Honor.
consequences.
defense?